The New York State Department of Education has identified a range of topics that will promote a healthy school environment in which students can learn and employees can work productively. Presented annually, this information sharing is known as compliance training. During this presentation, we will be discussing various procedures and protocols. At the conclusion of this presentation, you will be provided information to email any questions you may have to an individual knowledgeable about that subject for a response. So let us begin.
The first topic that will be covered is Right to Know. Developed by the Occupational Safety and Health Administration, OSHA, the Hazardous Communications Standard gives all employees the right to know what chemicals are used in the workplace, in addition to any or all the hazards associated with each. The hazards described will provide you with the awareness of both physical and health implications. School districts are required to possess and maintain an updated list of all chemicals used in their buildings in what was previously called Material Safety Data Sheets, or MSDS binder, which is now referred to as Safety Data Sheets, or SDS, which reflect the more universally globally harmonized system, GHS, of chemical identification. If you are experiencing a health problem that manifests itself while at work, you are encouraged to review the safety data sheets since they may reveal a product component to which you are allergic. Recently, a school custodian was experiencing coughing spells during her evening shift at work. Her allergist helped her review the safety data sheet for those products used in and around the building. This review helped identify her allergic reaction to a cleaning compound used in the classrooms. By changing the cleaning compound, her health issues improved. All chemicals used fall under specific guidelines approved by the school district. For this reason, no outside chemicals should be brought into the work environment without prior review of the SDS and approval from your administrator. If you are working with any chemicals on a daily basis, you will want to read and understand all labels and precautions to be aware of any health effects from prolonged use and exposure. In addition, it is vital to understand the best way to handle chemicals, thus minimizing unnecessary contact. Remember, when working with chemicals, you have the right to know.
Our next topic is blood-borne pathogens. Employees may be exposed to a disease at work if they administer first aid, clean spills of body fluids, or otherwise come in contact with blood or body fluids. OSHA defines blood-borne pathogens as infectious microorganisms present in blood that can cause disease in humans. These pathogens include, but are not limited to, hepatitis B, HBV, hepatitis C, HCV, and human immunodeficiency virus, HIV, the AIDS-causing virus. OSHA has specifically identified potentially infectious body fluids for which universal precautions must be taken when encountered. The most common fluids are blood, saliva, vomit, and urine. If you find yourself in the position of being exposed to any of these materials, it is essential that you use universal precautions, which means that you should treat all exposures to blood or body fluids as if the material presents an actual risk of disease. In order to reduce or eliminate the hazards of occupational exposure to blood-borne pathogens, OSHA has mandated that an employer must implement and annually update an exposure control plan for the worksite with details concerning employee protection measures. Should you have any questions, consult your administrator and ask to see the exposure control plan. In implementing universal precautions when exposed to potential blood-borne pathogens, first and foremost, protect your hands with latex or non-allergenic gloves that are included in all first aid kits, which can be obtained from the school nurse or the building principal. Any cloth or paper towel used to clean the fluid and your latex gloves must be deposited in a plastic bag-lined container, which is to be closed securely and disposed of properly as medical waste. Remove the latex gloves so as to avoid any fluid coming in contact with your skin. Note that the gloves are folded off your hands in a two-step process that begins with folding the wrist portion of your glove towards your fingers and ends with their full removal by grabbing the interior of the remaining glove. Deposit all cleanup materials in a lined receptacle and contact a custodian for its removal. Wash your hands thoroughly after any exposure. Finally, if you need assistance of any kind, consult the school nurse or custodian who has participated in more in-depth training in handling blood-borne pathogens. If you experience an exposure to blood or body fluids, or you anticipate being exposed to such materials as part of your job duties, you may consider immunization against hepatitis B. This immunization will be provided at the district's expense. See your school nurse or building principal for details. There is also some public concern of health issues surrounding HIV and AIDS. Based upon the current state of medical knowledge, there continues to be no evidence that AIDS or the HIV virus can be transmitted by casual social contact in a typical school or office setting. Accordingly, it is the policy of local boards of education that no student will be denied the opportunity to attend school or continue his or her education, nor shall any employee be prevented from continuing his or her employment solely based on having AIDS or HIV infection. This discussion of infectious disease and blood-borne pathogens reminds us all of the need to use universal precautions with exposures to blood and other body fluids.
Let's address the issue of sexual harassment. Sexual harassment of students or staff is illegal behavior that harms victims and negatively impacts the school culture by creating an environment of fear, distrust, intimidation, and intolerance. In 1984, the Supreme Court defined sexual harassment as behavior that is sexual in nature, unwanted, and usually pervasive, yet a one-time event could qualify. The Supreme Court further identified two types of sexual harassment: quid pro quo, or something for something, and hostile environment. Let us initially discuss quid pro quo. The definition of someone who might be harassing another person is an individual with authority or power over that individual. For example, a supervisor or building principal who approves your vacation request only after you have agreed to rub her back. Or if approval of a request for classroom supplies is tied to an agreement to have a quiet dinner together. In other words, quid pro quo harassment can only take place when a person in authority uses that authority to extract a sexual favor from you. Many people are in the dual position of being a potential victim of quid pro quo sexual harassment while also being considered a person in authority because of a teacher-student or supervisor-supervisee relationship. Any employee working or having contact with children should be mindful that, though well-intentioned, their actions might be misinterpreted by students. Something as simple as checking a student's work can be misinterpreted. If a teacher leans over a student to review an assignment, that student may become uncomfortable if he or she feels their space is being violated. Another example would be offering extra credit for after-school reading sessions, where a student sits on your lap, or you place your arms around, or otherwise regularly come into physical contact with the student. Such actions can be misinterpreted at best, can constitute sexual harassment at worst. You are asked to evaluate your words and actions as they might be perceived as sexually offensive in nature. When an incident of quid pro quo sexual harassment is founded, the school employer and the harasser are always liable. Let us now discuss the second type of sexual harassment, the hostile environment. A hostile environment exists when an individual or individuals feel that an environment is so sexually offensive that they cannot move freely throughout the environment. In other words, they are being discriminated against because they cannot enter or function effectively in a room, hallway, office, etc. For example, consider a break room predominantly used by a group of employees who constantly have conversations of a sexual nature. Other employees who also use that room might find these conversations embarrassing and offensive, and therefore not use the room. Therefore, they are being discriminated against because they cannot freely use a room made available to benefit all employees. So too can students experience hostile environment sexual harassment. Imagine a female student who feels very uncomfortable using a particular school hallway to get to class, since every time she uses it, the same male student makes sexual comments or remarks about physical attributes as a female. Her rights are being violated in that she cannot freely use a public space. At best, avoiding the hallway might make her late for class. At worst, she might start avoiding the class altogether. Again, as employees, you play a dual role in hostile environment sexual harassment. You might be the victim of this type of harassment, or you might be in a position to observe student-to-student or staff-to-staff sexual harassment. If you suspect that such behavior is sexually offensive, you must report it immediately to a building administrator for a proper investigation. In the case of hostile environment sexual harassment, the employer is held accountable if the situation was reported but not rectified, or if it is so evident that the administrator should have taken action independently. Sexual harassment can occur staff to staff, student to staff, and student to student. It can occur male to female to male, or female to female. It includes discrimination based on sexual orientation. Any student, employee, or third party, including visitors, vendors, etc., in the school building, is prohibited from sexually harassing any student or employee. Your employer has developed an independent grievance or complaint procedure to follow if you feel you are being sexually harassed or have observed sexual harassment. Upon receipt of a complaint, a prompt, thorough, and fair investigation will take place. If the complaint is founded, appropriate disciplinary procedures will follow. If the complaint is unfounded, established policy prohibits retaliation against any complainant or grievant.
Our next topic of discussion is the Dignity for All Students Act. DASA became effective July 1st, 2012. This law requires each school district to adopt a policy that prohibits all forms of discrimination and harassment of students based on actual or perceived race, color, weight, national origin, ethnic group, religion, religious practices, disability, sexual orientation, or gender by school district employees or students. Discrimination can be against any student by a student or group of students, or against a student by an employee or employees on school property or at a school function. Bullying and harassment can be physical or non-physical in nature. It can also be directed toward a non-distinct group or a particular person. For example, a popular clique in a school may not allow those outside their group to enter their space on a playground, playing fields, or in the cafeteria. However, in many circumstances, bullying is directed at one specific person. For example, a girl new to a school balances her food tray as she exits the lunch line. She timidly approaches a group of girls at a table with an empty seat. One girl quickly shoves her handbag into the empty seat so as to discourage the girl from sitting with them. Physical bullying is more obvious but no less emotionally traumatizing. For example, a few boys are standing in a hall joking when they spot a smaller classmate walking toward them. One of the boys sticks his foot out and deliberately trips the boy. Then they all laugh as the boy pulls himself together and gets up and continues down the hall. DASA also requires school districts to designate at least one staff member in each building as the Dignity Act coordinator. This person will handle harassment bullying complaints of students regarding race, color, weight, national origin, ethnic group, religion, religious practices, disability, sexual orientation, or gender. All incidents of harassment, bullying, and discrimination must be reported by the building principal to the State Education Department on an annual basis. Employees who are witness to the harassment and bullying discrimination must verbally notify the Dignity Act coordinator, building principal, the superintendent, or one of his or her designees of the alleged policy violation within 1 day after witnessing or receiving a report of the incident. Remediation in founded cases must be timely, and actions must be reasonably calculated to end the harassment, bullying, or discrimination. Effective July 1, 2013, cyberbullying was included in DASA. Cyberbullying is defined as any harassment, bullying, or discrimination that occurs through any form of electronic communication. This may happen in many forms such as cyberstalking, masquerading, phishing, flaming, harassment, and/or denigration. For example, a couple of boys create a false email account using the information of a fellow student. They send emails to other male students in the form of fraudulent love letters. They then print the emails and display them both on and off the school campus and proceed to verbally tease the student. This type of action can have a ripple effect in that not only is it extremely embarrassing and distressing for the student, but also his own friends and classmates may even exclude him from activities. Not only is cyberbullying in violation of the law, but all students are required to have instruction in the safe, responsible use of the internet and electronic communication. School districts are responsible to stop harassment and bullying if they know or should have known about the behavior. The Office of Civil Rights has stated that a school is sufficiently placed on notice of harassing behavior where the harassment occurs in plain sight, is widespread or well known to students and staff, occurs in the hallway during academic or physical education classes, occurs during extracurricular activities, recess, and on a school bus, or through graffiti in public areas. Students must also receive instruction supporting the development of a school environment free of discrimination, harassment, bullying, or cyberbullying. There are legal implications of DASA as well. Any person with reasonable cause to suspect a student has been subjected to discrimination or harassment by an employee or student on school grounds or at a school function, and who in good faith reports such incident or participates in any formal or informal proceedings shall have immunity from civil liability. School districts may violate the civil rights of students when peer harassment is either encouraged, tolerated, not adequately addressed, or ignored by school employees. Schools are liable when harassment is so sufficiently severe, pervasive, or persistent that it interferes with a student's ability to participate in or benefit from the services, activities, or opportunities offered by a school. Everyone is responsible to eliminate bullying in the district. This includes all district staff, members including teachers, support staff, administrative staff, and students. The Committee for Special Education also has responsibility for addressing bullying claims.
At this time, please turn your attention to school safety issues. Let us begin with school emergency disaster plans. Pursuant to the New York State Department of Education's Safe Schools Against Violence in Education SAVE legislation of 2001, each public school building is required to prepare and update an emergency response and crisis management plan. This plan articulates the procedures to be followed in the event of incidents ranging from severe weather conditions to a terrorist attack. Each plan details posted safety procedures and defines each role in student evacuations and any limitations to movements and routines inside lockdown or outside lockout your school building. Practices such as fire drills, early dismissal drills, intruder alerts, or other practice activities require each staff member's full participation and cooperation. As an employee, you are entitled to review your local plan. Please be reminded that each emergency disaster plan contains confidential information and should not be shared with students or the general public. The possibility of a bomb threat remains a clear danger for our schools. All school employees should be mindful of their surroundings and remain alert to suspicious packages or bags. If you notice a suspicious package or bag, immediately notify your building administrator or principal, who will initiate the appropriate emergency response. All staff and students must follow the directions of the emergency response team and any law enforcement or other authorized personnel. If you receive a bomb threat over the telephone, you should make every effort to identify characteristics of the caller. Is it a male or female? Did the caller have a discernible accent or other distinctive speech pattern? Did the caller seem agitated or calm? Were there any background sounds identifiable? Did the caller offer any clues as to where the bomb may have been placed or the time it may detonate? All of this information will be helpful to local law enforcement. Every employee should know the sequential dialing that will cause a telephone call to be traced. For example, dialing star and then a specific code may be applicable. In other words, star 69 or star 57 that allows law enforcement to retrieve the phone number. At the conclusion of the bomb threat call, you should immediately dial the sequence necessary to trace the call. Thereafter, contact your administrator, who must contact the superintendent's office to report the threat.
The safety of staff and students includes strong policies on the prevention of alcohol and substance abuse. First, it is important to know that the possession, use, distribution, and/or selling of chemical substances and alcoholic beverages on school property is prohibited. Alcohol or substance abuse by employees interferes with the central mission of educating students. Therefore, appropriate discipline and referral for prosecution will be imposed on any individual who violates this standard. Having said that, it is important to recognize alcohol abuse and chemical dependency as treatable diseases. Employees who are so diagnosed are entitled to the same consideration that is extended to employees with other types of illnesses. However, when this dependency negatively impacts an employee's job performance, the employee has an obligation to seek and respond positively to treatment. The appropriate school official can furnish you a list of service providers in the field of alcohol and chemical dependency. If an employee refuses or fails to respond to treatment and job performance continues to be affected, appropriate disciplinary action may take place. The confidential nature of the medical records for employees with alcohol or chemical dependency will be preserved, as are all other medical records.
Computers and related technologies are powerful tools that provide invaluable opportunities for communication and collaboration. Effective use of these technologies requires an awareness of their benefits and risks, and an understanding of their appropriate use both inside and outside the classroom. Employers have adopted policies and procedures for the proper and effective use of computerized information systems that includes independent use on school premises. All staff members are encouraged to utilize the computerized information systems available to them. The internet and email should be used to further the educational mission, goals, and objectives, to conduct research, and to communicate with others. When using these systems, you must abide by the terms and conditions of local policies, as well as state and federal laws and regulations. Information contained in student or staff databases is confidential and may not be shared with unauthorized persons. Individual passwords should never be disclosed. Unauthorized software should not be loaded, and inappropriate websites should not be accessed. Under all circumstances, computerized information systems must be used in a professional manner.
Let's talk about mandated reporters. Certain professionals, including school physicians, nurses, teachers, administrators, licensed OTs and PTs, and others, are mandated reporters because they are required by law to report suspected child abuse or maltreatment to the New York State Central Register of Child Abuse and Maltreatment. This register is commonly known as the Child Abuse Hotline. Within a school setting, all certified staff are mandated reporters and must complete a 3-hour course to receive their initial certification or any new credential. Mandated reporters are required to report or cause a report to be made when they are presented with reasonable cause to suspect child abuse or maltreatment. The term reasonable cause means that, based on your observations, professional training, and experience, you feel the parent, guardian, or person legally responsible for a child has harmed that child or placed that child in imminent danger of harm. Abuse encompasses the most serious harms committed against children. An abused child is one whose parent or other person legally responsible for his or her care inflicts physical injury upon the child or commits a sex offense against the child. A person can also be suspected of child abuse if he or she knowingly allows someone else to inflict harm. Common indicators of physical abuse are frequently appearing injuries, such as bruises, cuts, or burns. Other behavioral clues are destructive, aggressive, or disruptive behavior, severe withdrawal, or expressed fear of going home. Indicators of sexual abuse also include sexually suggestive or promiscuous behavior, expressing age-inappropriate knowledge of sexual relations, and difficulty or pain when sitting or walking. Maltreatment means that the parent or legal guardian's failure to exercise a minimum degree of care has jeopardized a child's physical, mental, or emotional condition. This means a failure to provide sufficient food, clothing, shelter, or proper supervision, and/or a failure to provide education or medical care. Maltreatment also includes excessive corporal punishment or the misuse of alcohol or drugs that places the child in danger. Common indicators of maltreatment include obvious malnourishment, stealing or begging for food, lack of personal care, and frequent absence from school. As soon as you suspect abuse or maltreatment, you must report or cause a report to be made to the Central Register via the telephone hotline. The hotline is open 24 hours a day, 7 days a week to receive your call. The timeliness of your call is vital to the timeliness of the intervention by local child protective services. The telephone numbers are Mandated Reporter 800-635-1522, Public Hotline, 800-342-3720. Before making a call to the hotline, you should use the mandated reporter form to help you organize the information you have. The completed form must be sent to the Central Register within 24 hours of making the call. When a report is received, a determination will be made as to whether or not an investigation is warranted. If an investigation is warranted, the Department of Social Services is immediately notified for investigation and follow-up. Intervention consists of an evaluation of the child and other children in the home, and the development of a plan to meet the needs and safety of the child and family. If an investigation is not warranted at this time, you are encouraged to continue observing the child. The reporting of new and additional information may cause a re-evaluation of the facts and subsequent investigation. The Social Services law provides confidentiality for the mandated reporters. If a mandated reporter makes a report with earnest concern for the welfare of a child, he or she is immune from any criminal or civil liability that may result. Anyone who is mandated to report suspected child abuse or maltreatment and fails to do so could be charged with a Class A misdemeanor and is subject to criminal penalties.
Our final topic of discussion is child abuse in an educational setting. All mandated reporters and school staff must also be aware of procedures to report child abuse in an educational setting. The SAVE legislation provides the process for dealing with child abuse in an educational setting. When a school employee receives an allegation that child abuse has occurred, he or she must promptly complete a written report form and personally deliver this form to the building administrator in which the alleged abuse occurred. Such forms are available from the building principal or the superintendent. This confidential report of an allegation must be promptly investigated by the building principal. In the event the building principal is the subject of the allegation, the report is to be received by and then an investigation conducted by the superintendent of schools. If the subject of the allegation is not a member of the reporting employee's school district, the report of the allegations must be provided to the superintendent of schools where the employee works. By law, the building administrator or the superintendent are the only persons authorized to receive these written reports. As part of a prompt and thorough investigation, the parent of the student is notified. The student and the employee are interviewed, and any other relevant information is collected while maintaining confidentiality. At the conclusion of the investigation, the building principal submits to the superintendent a confidential report of allegation with a determination whether or not there was reasonable suspicion of child abuse. If reasonable suspicion is found, the superintendent must notify appropriate law enforcement and the state education department. If reasonable suspicion is not found, the report may be kept on file for up to 5 years. Failure to prepare and submit a form by a school employee or board member is a Class A misdemeanor. Willful failure of a building administrator or superintendent to forward a copy of the report to appropriate law enforcement is also a Class A misdemeanor. An agreement to accept a resignation in lieu of appropriate reporting, also called silent resignation, is clearly prohibited and also punishable by fine. I hope you found this presentation informative. I encourage you to email any questions you might have to the knowledgeable individuals identified for each topic in your supporting documentation or to your administrator supervisor. Thank you for your attention and your commitment to a safe, healthy, and productive school environment for students, employees, and community members.